difficult question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done. So, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it is in the McFoy case, it's an English authority, that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
Because I think nobody here actually took those questions seriously, they didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see, is that this, by the law, by Article 138(3)(c), it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, well, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked yesterday, why was it not declared to everybody? And that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina Kiai case, but you were quoted paragraph 287 of the Supreme Court, which I called RILA, which was RILA 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjiku Constitution that we have. It's transformative, and some people say it's a very overused word, but in these circumstances it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And In closing, whilst we said we were talking